Jungle.
News on contract revealed. News on voidable and unenforceable contract revealed. Delivering nothing but the truth. This is TBC News, your contract or business. Good day everyone, this is Group 4 bringing you the hottest and honest details on business contracts. I am Kyla Garduque and this is TBC News. For the details of Articles 3090 to 3091, here is Joyce Legaspi.
All over the world, many people are entering an agreement from various organizations, companies, or just between parties, either for businesses or personal reasons. Though, how do we know if a contract is voidable or not?
What is voidable contracts? Are those which possess all the essential requisites of a valid contract, but one of the parties is legally incapable of giving consent, or consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. When two parties agree, the contract is enforceable and valid. These parties have certain rights and liabilities as per the voidable contract section. If either parties notices flaws or missing facts, they have the right to reject this contract. In contrast, if they are ignorant of such facts, they can be a victim of fraud. However, they can still execute the contract. Simply means these are contracts that became invalid if one of the parties is legally incapable of giving consent, like minors and mentally incapacitated persons, or those who are mentally impaired, or when the signed consent is under violence or undue influence. Let's talk it further on our Article 1390. According to Article 1390, the following contracts are voidable or annullable even though there may have been no damage to the contracting parties. First, those where one of the parties is incapable of giving consent to a contract. Just like what I have mentioned, these are people who are incapable or have no rights to give consent to a contract, just like minors who haven't reached their maturity age or people who have disabilities or impaired. Second, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud, when one or both parties were duped, coerced, or blackmailed into signing a contract, the agreement becomes voidable. However, even though the other party is now under duress, either party may opt to maintain their contract under the new terms and conditions. If the permission was given freely and without compulsion, fraud, or misinterpretation, the contract would be enforceable. Additionally, if the consent was silent and the party has all information necessary to know the facts, the contract would not be void in that situation. So, these contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. So what is ratification? It is a legal way to continue the contract that has been agreed upon between parties with new terms and conditions of agreement. It means even if the contract is voidable, the parties can ratify their contract by making another agreement and changes in the contract. So what are the causes of voidable contracts? First, undue influence. It is where individual uses power to make another person sign into a contract. For example, A threatens B to sign a contract to sell his property or else he will be killed. Second, being a minor. People who are underage who have entered a contract can lead to unenforceable contracts. Hence, the contract is voidable when the other parties have learned about the minor age. However, it can be ratified once the individual has reached its maturity stage. And third, mentally incompetence. Individuals who are mentally incapable can turn a contract voidable. People who have disabilities and mentally impaired are under this category. For example, A was drunk and had no capability to enter a contract, but was forced to sign an agreement of having a loan of 20,000 pesos with an interest of 10% monthly. Clearly, the contract is voidable as one party is under the influence of alcohol. Why is it voidable? Because A was drunk and he is incapable of signing a contract. He was not on his right mind and was forced to sign the contract against his will. In Article 1391, the action for annulment shall be brought within 4 years. This period shall begin in cases of intimidation, violence, or undue influence from the time the defect of the consent ceases. For example, Kitty was intimidated into signing a contract on September 1, 2023. The intimidation continues until January 1, 2024. When will the 4-year period start? The 4-year period for annulment of contract will start from January 1, 2024, where the intimidation has already ceased. In case of mistake or fraud, from the time of the discovery of the same. For example, Kitty and Dale entered into a real estate contract on January 29, 2025. After 6 months, Kitty discovered the fraud employed by Dale in the contract for the property. Kitty must file an annulment of the contract within the 4-year period at the time of the discovery of the fraud, which exactly starts on July 29, 2025. And when the action refers to contracts entered into by minors or other incapacitated persons from the time the guardianship ceases. For example, Brent entered into a contract on January 1, 2020 when he was exactly 16 years old. The contract is voidable until he reaches the maturity stage in which he no longer needs parental support. Simply, Article 1391 states that the filing for annulment should be brought within 4 years where the intimidation, violence, fraud, guardianship ceases and discovered.
This is Joyce Maria Siligaspi reporting for TBC News.
Articles 1392 to 1395 will be reported by Ira Ernesto. Ira?
Article 1392. Ratification extinguishes the action to annul a voidable contract. This article means you modify or approve your contract even though you are aware of a defect in it. You know that you have the option to have the contract annulled, but you chose to ratify or be bound by the agreement instead. The action to annul is extinguished, as if someone truly retroacted from the time when your contract is constituted. So, ratification cleanses the contract from all of its defects from the moment it was constituted.
Let's take a look at example number 1. J.A., a minor, bought a land. Upon reaching the age of majority, he sold the land to K.C. The action to file for annulment of contract was extinguished. After J.A. reached the legal age and sold the land to K.C., he was no longer able to bring an action to revoke the agreement because there had already been implied ratification when he sold the property to others after reaching the legal age, which is regarded as an act of ratification. Let's move on to example number 2. Queen Yas, a minor, sold her land to Queen Min. Upon reaching the age of majority, she collected the unpaid balance. The action to file for annulment of contract was extinguished. Queen Yas sold her land to Queen Min while still a minor, and as she was still incapable of making decision at the time, she confirmed their agreement by collecting the balance that remains rather than immediately bringing an action for annulment.
Article 1393. Ratification may be effected expressly or tacitly. It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract unvoidable, and such reason having ceased, the person who has the right to invoke it should execute an act which necessarily implies an intention to waive his right. In this article, the two types of ratification expressed and implied are discussed. Additionally, in accordance with this article, if a party has knowledge of the factor that makes a contract voidable, because of that knowledge, that factor has ceased to exist. If the factor was intimidation, intimidation has taken root, and a party who has the right to invoke should take action which implies ratification.
We have two kinds on how ratification is made, the express and implied or tacit. Express means it is manifested orally or in writing. Implied or tacit, it means that it indicates that he is waiving his right to bring an action for annulment based on the act of the waiver. Requisites of implied ratification. It is necessary to be aware of the condition that makes the contract void. First, there must be knowledge of the reason which renders the contract voidable. If the party seeking to ratify is unaware of the circumstances that render the agreement voidable, there can be no ratification. In order for there to be an implicit ratification, the party must be aware of the ground that renders the contract voidable. Otherwise, there are unable to be an inferred ratification. Second, such reason must have ceased. And last, the injured party must have executed an act which implies waiver.
Article 1394. Ratification may be effected by the guardian of the incapacitated person. In this article, it is discussed that if a person who entered into a contract is incapable of giving consent due to their incapacity, their guardian will ratify the agreement on their behalf because they are unable to do so themselves. The party in charge may also ratify the agreement, but the reason why it became voidable must first be ceased. If he's still a minor, he must wait until he is of legal age. Though, in that case, his guardian can approve the voidable contract.
What is a ratification? It means that it entails the processing of your verification or validation and the setup of the legality of your contract. What is a incapacitated person? Are those who are unable to manage their own matters. Incapacitated person includes minors, dyslexia, deaf, muted. Minors at ages 17 and below. Dyslexia, it is a person who is unable to identify speech sounds and learn how they relate to letters and words or reading disability. Deaf muted, both deaf and couldn't speak that only uses sign languages. A contract that has already been signed by the incapacitated party may be void. The contract can be ratified by the incapacitated person to make it legally binding after it is established that they are capable of doing so. For example, a minor who becomes capable after reaching the age of majority. Only the guardian can be approved by a person who is incapacitated. For instance, John, who is unable to function due to mental health concerns, has contracted with a mechanic to fix his car. Since John is an incapable individual, his contract may be void. So who can ratify? John's contract will be officially confirmed and declared valid by his guardian, who will provide their approval.
Article 1395. Ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. This article discusses the fact that the guilty party's consent is no longer required. When it comes to ratification, the injured party's ratification is the only thing that is actually required. The guilty party is not required to comply and is not required to consent. For instance, if the guilty party wants to claim that the contract is avoidable, but also wants to ratify it, this is not possible because only the injured party has the legal authority to do so. As a result, either the party with consent or the incapable person who cannot give consent is vitiated.
Who are the guilty party? Does not require to give consent or conformity. It is the people who do not have the right to ratify or annul. who are the injured party, has sole power to annul a contract and decide whether to do so. It has the right to decide what he wants to do. For example, we have three characters: MJ, the owner of the motorcycle; JK, the tourist rider; AA, the traveler or the tourist. In order to bring tourist, JK, a tourist rider, rents out MJ's motorcycle. AA is a traveler, so she borrowed JK's motorcycle so that she could explore the area. Since JK already has the motorcycle rented, MJ doesn't need to agree or comply in order to ride the motorcycle. Therefore, when it comes to the ratification of a contract or agreement, your consent or compliance is not necessary if you are guilty.
This is Ira reporting for TBC News.
Articles 1396 to 1398. Here is Karil Cassandra de los Reyes for the report.
In Article 1396, ratification cleanses the contract from all its defects from the moment it was constituted.
But first, what is ratification? Ratification is the approval of agreement by the state. Requisites of ratification. Number 1. The contract must be voidable. Number 2. The person ratifying must know the reason for the contract being voidable. Number 3. The cause must not exist to continue to exist anymore at the time of ratification. Number 4. The ratification must have been made expressly or by an act implying a waiver of the action to annul. Number 5. The person ratifying must be the injured party. Although there is a retroactive effect, the rights of innocent third persons must not be produced. Who can ratify? The party who can annul the voidable contract. For Article 1396 example. So, B is a minor and sold land to C. After some time, B came of age. The land he sold was insufficient to pay for. And when he is at the right age, he can now cancel the contract because he is just a minor when he sells the land. But instead of canceling the contract, he just got back the balance, and that action will ratify the contracts.
In Article 1397, the action for the annulment of contracts may be instituted by all who are thereby obliged, principally or subsidiary. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employ the fraud, or cause mistake base their action upon these flaws of contract.
The vices of consent. Number 1. Violence. When in order to wrest consent, serious or irresistible force is employed. For example, Ali asked Mira to buy her cell phone for $2,000. Mira refused it. Ali then punches Mira in the face until she agreed to buy it. Number 2. Intimidation. When one of the parties to the agreement is required to offer his approval because of a valid fear of an impending serious harm to his person or property. The difference between intimidation and violence is that in violence, there is a physical contract. Here, there is none. So, intimidation, it is a pagbabanta. For example, Elgin asked Ken to lease Ken's land or else he will set Ken's house in fire. Exemption intimidation. A threat to enforce one's claim through competent authority if the claim is just legal, does not violate consent. For example, Elgin asked Ken to Ken's land or else he will sue Ken because he violated Elgin's right of the easement regarding to Ken's property. Mistakes refers to the substance of the object, identity, qualification of a person, or conditions that have principally moved one or both parties to enter into the contract. For example, Andre believing that Adrian is his long-lost brother. agreed to donate him a house and lot. So it is a mistake of fact. So another example. Sarah sold to Mira a diamond ring. Later on, both of them found out that it is fake. Fraud. Through insidious words or machination of one of the contracting parties, the other is induced to enter into a contract, which without them would not have agreed to. Like without them, without fraud. Dolo incidente never violate consent and never result to voidable contract, while dolo cosciente vitiates consent and will eventually make a contract voidable. For the last one, undue influence. When a person takes improper advantage of his power over the will of another, depriving the latter of a reasonable freedom of choice. Example, your prof asks to marry you. You are of age, but the biggest factor for you saying yes is because he is your prof. And if you say no, you are afraid he might be disappointed and fail you.
Article 1398. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits, and the price with its interest, except in cases provided by law. An obligation to render service, the value thereof shall be the basis for damages.
According to this article, if the annulment is still not processed, the parties are just exempted from their obligation. Nevertheless, if a complaint is filed, we will have a situation similar to the rescission, where there will be a mutual restitution. Fruits and prices with interest will therefore be restored. When it comes to private obligation, the obligation stated in the last sentence will serve as the basis for determining the value of the service provided in exchange of damages. Mutual restitution, it is the purpose of the law, is to restore the parties to their original situation by mutual restitution. Then mutual restitution is required in cases involving rescissions under Article 1191. Restitution is just an act of restoring. Restitution is meant to make things fair and prevent one side from unjustly enriching themselves. It is applied in contractual situation when one party provides another party a benefit, but it is unable to get payment because the contract is annulled or there is no agreement. For example, for instance, the sale agreement is void. If delivery and payment have already been made, the seller must restore the purchase amount plus interest, and the customer must return the goods he acquired. Furthermore, if there were any fruits or on the property, they are included in the amount that the buyer will pay back along with the purchase price that the seller added with interest. And that's all for Article 1396 to 1398. I am Casey De Los Reyes, reporting.
For the details of 1399 to 1401, here is Sean Derek Imperial.
Article 1399. When the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him.
Restitution by incapacitated person. This provision is an exemption to the general rule of mutual restitution. Under the preceding article, the incapacitated person is obliged to make restitution only to the extent that he was benefited by the thing or price received by him. It results therefore that if he was not benefited, he is not obliged to restore what he had received, but the other contracting party is still bound to return what he had received, whether he was benefited or not. It is not necessary for the minor to be considered benefited that he invested the thing or amount received. It is sufficient if he has kept it. The party whose capacity has the burden of providing the benefit or profit received by the incapacitated person. Enrichment of the incapacitated party is not presumed. An exemption of the rule of mutual restitution is also provided in Article 1427. Example: two miners together with their mother borrowed money during the Japanese occupation from Villa Abril. The money was used for the support of the miners, with a promissory note signed by the miners promising to pay 10,000 pesos in 2 years. It is voidable and annulled by the court. The miners were required to return the money they received from the Villa Abril as they profited by the use of thereof. Whether or not the capacitated party has benefited from what he received from a minor, he must return the same except when he received the thing from the minor in the performance of the latter's natural obligation, and what had been received had been spent or consumed in good faith.
Article 1400. Whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss, with interest from the same date.
Effect of loss of thing to be returned. 1. If the thing to be returned is lost without the fault of the person obliged to make restitution, there is no more obligation to return such thing. But in such a case, the other cannot be compelled to restore what in the virtue of the decree of annulment he is bound to return. If it's lost through his fault, his obligation is not extinguished but is converted into an indemnity for damages consisting of the value of the thing at the time of the loss, with interest from the same date and the fruits received from the time the thing was given to him to the time of its loss. Example: Aliyah sold his plow Carabao to Nell. On the petition of Aliyah, the contract was annulled by the court, but the Carabao died in the possession of Nell through his fault. Under Article 1400, Nell must pay the value of the Carabao at the time of its death, with interest from the same date. If the Carabao had given birth, the young must also be delivered as the fruit of the said animal.
Article 1401. The action for annulment of contract shall be extinguished when the thing which is the object thereof is lost, through the fraud or fault of the person who has the right to institute the proceedings. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action, unless said loss took place through the fraud or fault of the plaintiff.
Extinguishment of action for annulment. 1. If the person who has a right to institute an action for annulment will not be able to restore the thing which he may be obliged to return in case the contract is annulled because such thing is lost through his fraud or fault, his right to have the contract annulled is extinguished. If the loss is not due to his fault or fraud, Article 1402 applies. The action for annulment shall be extinguished only if the loss is through the fault or fraud of the plaintiff. 2. Under the second paragraph, the right of action is based upon the incapacity of any one of the contracting parties. Whether the right of action is based upon incapacity or not, the rule is the same. It is no longer necessary that the fraud or fault on the part of the plaintiff resulting in the loss must have occurred after having acquired capacity. As under the old code, this qualification has been deleted in the present article. The deletion has made the second paragraph redundant. Example: Shan coerced Yen to sell to him a car. Yen seek the annulment of the sale. However, if Yen lost the car by intentionally destroying it, he cannot file the annulment case. As such, right will be considered extinguished.
This is Shanderk S. Imperial reporting for TVC News.
Article 1402 will be reported by Lark Eusebio. Lark?
Thank you, Kyla. Article 1402.
As long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot compel to comply with what is incumbent upon him. When a contract is annulled, a reciprocal obligation of restitution is created. The return by one party of what he is obliged to restore by the decree of annulment may be regarded as a condition to be fulfillment by the other of what is incumbent upon him. In effect, there will be no annulment if the party cannot restore what he is bound to return. This is true even if the loss is due to fortuitous event. However, If the party who lost the thing through a fortuitous event offers to pay its value with the fruits received, if any, there is no liability to pay interest since the loss is without his fault. The other can be required to make a restitution. For example, Jay entered into a contract with Zola's whereby he obliged himself to create a wooden statue in the image of Zola's mother. However, it turned out that Zola is only 12 years old, and as such, he is incapacitated to enter into a contract. The contract was annulled. Zola was then obligated to return the statue while Jay has the obligation of returning the money paid by Zola for the statue. Since Jay did not return the money, Zola cannot be compelled to return the statue, as provided for by Article 1402.
For the details of Article 1403 will be reported by Kyla Garduque. Article 1403, an enforceable contract. An enforceable contract is valid but not binding or enforceable. Even if a contract is valid, it cannot be enforced in the court unless it is ratified or cleared as if they don't have effect as of yet. These contracts can be enforceable after being ratified. Ratify means approved to or enact a legally binding act that would not otherwise be binding in the absence of such approval. What is an enforceable contract? Unenforceable contracts are those that cannot be enforced in the court or sued upon by reasons of defects provided by the law until and unless they are ratified according to the law. Simple terms, the court will not demand performance from the opposing party or impose damages if the agreement is determined to be unenforceable. But what makes a contract unenforceable? Number 1. Those entered into the name of another by one without or acting in excess of authority. Number 2. Those that do not comply with statute of frauds. And last but not the least, those where both parties are incapacitated. Let's start with the first kind of unenforceable contract, which is the unauthorized contracts. The person who entered the contract is not the one who owns the property or will provide the service, rather it is another person. Depending on what type of contract, this additional person will enter a contract on behalf of the owner or a person providing the service that may not have an authorization or have the authorization but goes beyond what are legally allowed to. Now, let's give an example of an authorized contract. Hyunzino sells Hoshi's land without Hoshi's permission. This is an example of an authorized contract because Hyunzino doesn't have a necessary authorization and Hoshi did not ratify the contract, hence, it is unenforceable. Number 2. Hoshi offered Hyunzino the chance to lease or mortgage the parcel of property, but Hyunzino decided to sell it. There is authority, but it exceeds the authority granted, making it an enforceable contract. Now, let's go to the second kind of unenforceable contract, which is the statute of frauds. The purpose of the statute of frauds has been enacted not only to prevent fraud, but also to guard against the mistakes of honest men by requiring that certain agreements specified that are susceptible to fraud must be in writing. Otherwise, they are unenforceable by action in court. For those enumerated agreements under the statute of frauds to be enforced in court, they must be in writing, and there are rules of application of statute of fraud. The first rule of application of statute of frauds is that the statute of fraud is not applicable in actions which are neither for damages because of a violation of a contract nor the specific performance thereof. This means that the statute of frauds are only applicable to actions for damages or for a specific performance. Next rule, it is applicable only to completely executory contracts, not the contracts which are totally executed or partially executory. What is executory contracts? Executory contracts means that nothing has been performed under the contract. While executed or partially executory contract, there is a performance on the side of one party or both of the parties. Next rule, it is only applicable where the contract is admitted expressly or impliedly by the failure to deny specifically its existence, no further evidence thereof being required in such case. This means that if the verbal agreement is acknowledged, it is no longer covered by the statute of frauds because the defendant acknowledged the existence of such an agreement which the plaintiff need not justify. Next rule, it is applicable only to agreements enumerated therein. If it is not one of the agreements listed in the statute of fraud, it is not covered by the statute of frauds because the lease is exclusive. Next rule, it is not applicable where a writing does not express the true agreement of the parties. Next, it does not declare that contracts infringing it are void, but merely unenforceable. Unenforceable contracts which violated by the statute of frauds can be ratified. Next rule, the defense of the statute of frauds may be waived. Last rule, the defense of the statute of frauds is personal parties and cannot be interposed by strangers to the contract. This means that only the defendant can say that the agreement is covered by the statute of frauds. Now, let's go to the agreement within the scope of the statute of frauds. Number 1. Contracts not to be performed within a year. For example, Minghao and Honey verbally agreed to form a partnership after 13 months. Minghao advised Honey to join a partnership on the 13th month. But Honey had no intent in doing so at that time. The contract is unenforceable because it was only done verbally and falls under the statute of frauds. Thus, Honey's disagreement is justified. Number 2, a special promise to answer for the death, default, or miscarriage of another. For example, DK is indebted to June. Nikki orally guaranteed DK's debt. Nikki has a special promise to answer for the debt of DK in case DK fails to pay June. Because the guarantee agreement was only made orally and cannot be enforced without being in writing, the creditor cannot appeal to the guarantor in this situation. Unless it is in writing and is signed by Nikki, the agreement is not enforceable. Number 3, agreement in consideration of marriage. For example, in exchange for Jake marrying his daughter Joy, Jay verbally promised to give Jake a parcel of land and building. In one scenario, Jake and Joy were already married when Jake approached Jay for the building and parcel of land he had promised. Jay declined to fulfill his duty. Jay's behavior is justified because the agreement was only made orally and not in writing, making it unenforceable. But a mutual promise of Jake and Joy to marry each other need not to be in writing. Number 4, agreement for sale of goods, etc. at price not less than 500 pesos or more. For example, Jungwoo and Lino mutually promised to sell and buy a bicycle at a price of 8,000 pesos. This contract must be in writing to be enforceable against either party. In one scenario, Lino already gave 8,000 pesos for the payment of bicycle. This is when exception applies. When something has been delivered or has been paid for in part or in full, it has been partially executed. The contract may now be enforceable even if it was made orally because it is no longer covered by the statute of frauds because it has been partially executed. Number 5. Agreement for leasing for a longer period than 1 year. For example, Erie agreed to lease her house to JK for 3 years. This agreement must be in writing to be enforceable unless it is partially executed. If you verbally lease personal property, it is acceptable and does not fall under the statute of frauds, regardless of how long you intend to keep the lease in effect. Whatever the form, it is valid if it is personal property. Number 6. Agreement for the sale of real property or often interest therein. For example, Jaehyun orally sold his land or his right of usufruct in said land to Win-Win. The agreement is unenforceable unless it has been partially executed. Jaehyun agreed in a private document to sell his land to Win-Win. The document was given to Win-Win, who lost it. May Win-Win prove the agreement by oral evidence? Yes, Win-Win must prove the agreement by oral evidence. Number 7. Agreement for the sale of goods, etc. at price not less than 500 pesos or more. For example, Jungwoo and Lino mutually promised to sell and buy a bicycle at a price of 8,000 pesos. This contract must be in writing to be enforceable against either party. In one scenario, Lino already gave 8,000 pesos for the payment of bicycle. Win-win must show that there is a written instead of an oral sale contract. However, win-win must initially provide evidence that a written agreement actually exists. Number 7, a representation as to the credit of a third person. For example, Adrian, an insolvent, is in need of money. Paolo was approached for assistance by Adrian. Josh, a solvent party, extended a loan to Adrian as a result of Paolo's oral assurance that Adrian had good credit. The contract must be in writing to be enforceable. Before we go to the last kind of unenforceable contract, let me remind you to the exemption. Number 1, if a contract is partially executed, statute of frauds are no longer applied. Number 2, a partially executed contract is not applicable to both parties who are incapacitated and unauthorized contracts. It is only applicable to statute of frauds. The last kind of unenforceable contract is the incapacity of contracting parties. This means that both parties are unable or incapable of giving consent to a contract. Let me give you an example of this. Jonghan, a minor, decided to sell his piano to Tino, who is also a minor. If both Dino's parents and Jonghan's parents ratify the contract, there is an exemption. This means that a contract is now enforceable and valid. Another example of a person who is incapable of giving consent is a person with mental disability. And that's all for Article 1403, Unenforceable Contract. This is Kyla Gerduque reporting. Article 1404 to 1405 will be reported by Micaela Mindon. Mika?
Article 1404, unauthorized contract shall be governed by Article 1317 and the principles of agency in Title 10 of this book. Other provisions of law that governs unauthorized contracts are the following. Governing principles are Article 1317, Title 10 of Civil Code of the Philippines, and Articles 1868 to 1932. Article 1317 states that no one may contract in the name of another without being authorized by the latter or unless by law or right to represent him. A contract entered into the name of another by one who has no authority or legal representation or who has acted beyond his powers shall be unenforceable unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by the other contracting party. Title 10, Funerals Article 305 to 310, the sale of property made by a person without the authority of the owner is null and void from the beginning but afterwards becomes perfectly valid and is cured of the defects by the ratification made by the owner under oath that he had consented to the former on making the said sale. And Articles 1868 to 1932, in the law of agency under Title 10 of the Code, unauthorized contracts are susceptible to ratification. So, for your information, ratification means confirmation or adoption of an act that has already been performed. The requisites for a person to contract in the name of another: he must be duly authorized, expressly or implied. He must have by a law right to present him like guardian or administrator, and the contract must be subsequently ratified. Article 1405. Contracts infringing the statute of frauds referred to in number 2 of Article 1403 are ratified by the failure to object to the presentation of oral evidence to prove the same or by the acceptance of benefit under them. Unenforceable contracts may be ratified in two ways. Number 1 is failure to object to the presentation of oral evidence. This is tantamount to a waiver. Contracts that are infringed in the statute of frauds are ratified by the failure to object to the presentation of oral evidence and are enforceable. Number 2 is acceptance of benefits. Under this contract is equivalent to a waiver or estoppel, only applies to executory contracts. If the oral contract was reduced into writing by the party charged, this exercise is called recognition. It is the express ratification of the contract. So we have here an example of failure to object. Ella and Lawrence entered into an oral contract of sale where Ella sold his land to Lawrence. When Lawrence sued Ella to enforce the contract, Lawrence presented the testimony of witnesses to prove that the contract existed. Ella did not object, binding upon the parties as if it had been reduced to writing. Next is acceptance of benefits. When a party to a contract receives the benefit from the contract, the statute of frauds no longer applies. The acceptance or partial performance already serves as evidence of the existence of the contract. If the party in whose favor the statute may be invoked, cross-examine the witness who is testifying on the oral contract. The former is deemed to have waived the right to object to the admission of the testimonial evidence. The party should promptly object to the presentation of the witness once it becomes apparent that no evidence in writing could be presented to prove the contract. The objection must be invoked during the offer of the testimony of the witness, or a motion to dismiss may be filed before an answer to the complaint is filed. Article 1404, an authorized contract shall be governed by Article 1317 and the principles of agency in Title 10 of this book. Other provisions of law that governs unauthorized contracts are the following. Governing principles are Article 1317, Title 10 of Civil Code of the Philippines, and Articles 1868 to 1932. Article 1317 states that no one may contract in the name of another without being authorized by the latter or unless by law or right to represent him. A contract entered into the name of another by one who has no authority or legal representation or who has acted beyond his powers shall be unenforceable unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by the other contracting party. Title 10, Funerals, Article 305 to 310. The sale of property made by a person without the authority of the owner is null and void from the beginning but afterwards becomes perfectly valid and is cured of the defects by the ratification made by the owner under oath that he had consented to the former on making the said sale. And Articles 1868 to 1932 in the Law of Agency under Title 10 of the Code, unauthorized contracts are susceptible to ratification. So, for your information, ratification means confirmation or adoption of an act that has already been performed. The requisites for a person to contract in the name of another: he must be duly authorized, expressly or implied. He must have by a law right to present him like guardian or administrator, and the contract must be subsequently ratified. Article 1405. Contracts infringing the statute of frauds referred in number 2 of Article 1403 are ratified by the failure to object to the presentation of oral evidence to prove the same or by the acceptance of benefit under them. Unenforceable contracts may be ratified in two ways. Number 1 is failure to object to the presentation of oral evidence. This is tantamount to a waiver. Contracts that are infringed in the statute of frauds are ratified by the failure to object to the presentation of oral evidence and are enforceable. Number 2 is acceptance of benefits. Under this context is equivalent to a waiver or estoppel, only applies to executory contracts. If the oral contract was reduced into writing by the party charged, this exercise is called recognition. It is the express ratification of the contract. So we have here an example of failure to object. Ella and Lawrence entered into an oral contract of sale where Ella sold his land to Lawrence. When Lawrence sued Ella to enforce the contract, Lawrence presented the testimony of witnesses to prove that the contract existed. Ella did not object, binding upon the parties as if it had been reduced to writing. Next is acceptance of benefits. When a party to a contract receives the benefit from the contract, the statute of frauds no longer applies. The acceptance or partial performance already serves as evidence of the existence of the contract. If the party in whose favor the statute may be invoked, cross-examine the witness who is testifying on the oral contract. The former is deemed to have waived the right to object to the admission of the testimonial evidence. The party should promptly object to the presentation of the witness once it becomes apparent that no evidence in writing could be presented to prove the contract. The objection must be invoked during the offer of the testimony of the witness, or a motion to dismiss may be filed before an answer to the complaint is filed.
Articles 1406 to 1407 will be reported by Christian Dragon.
Article 1406. When a contract is enforceable under the statute of frauds, and a public document is necessary for its registration in the registry of deeds, the parties may avail themselves of the right under Article 1357. This clause can only be used if there is a legitimate agreement that does not violate the statute of frauds. The first one, as a result, a party to an oral real estate deal cannot compel the other side to record the agreement because it is void under Article 1403 unless it has been approved by Article 1405. Similar to how a donation of reality, when it is in a private instrument, is null, neither party has the power to require the other to sign a public document by Article 1356. Example, a buyer buys a motorcycle from a seller, only to find out later that the vendor failed to disclose a significant flaw with the motorcycle. Under Article 1406, which stipulates that a contract may be cancelled if there was an error, fraud, or undue influence that taints one of the parties' consents, may be invoked by the buyer to do so. The seller's omission to disclose the flaw in this instance vitiates the buyer consents, and the buyer may be entitled to terminate the contract and request a refund of a purchase price. Article 1407. In a contract where both parties are incapable of giving consent, express or implied ratification by the parent or guardian, as the case may be, one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parent or guardian, as the case may be of both contracting parties, the contract shall be valid from the inception. Discussion. The contract may be ratified if neither party to the alleged contract is incapable of consenting, in which case it is not binding and cannot be enforced in court. The first one is, if only one party to the contract has been ratified, the contract was changed into a voidable contract on the part of the person who was not ratified by the parent or guardian, which means it is now legitimate and binding unless it is quashed by the court. The contract is deemed effective from the outset if it is approved by the parent or legal guardian of both parties. The approval goes back in time. The last one is, if the party's reason of incapacity such as minority has passed the majority age of, or if their insanity has returned, they must. Example, a landlord rents out a commercial space to a tenant, but later discovered that the tenant has been using the space for illegal purposes. The landlord may seek rescission of the contract under Article 1407, which allow for rescission of a contract if the cause of the obligation no longer exists due to the fault of one of the parties. In this case, the tenant's illegal use of the space has been rendered. In this case, the tenant's illegal use of the space has rendered the contract void, and the landlord may be entitled to rescind the contract and seek damages for any harm caused by the tenant's action.
This is Christian Van Dragon, reporting for TBC News.
Article 1408 will be reported by Lord Eusebio.
Thank you, Kayla. Article 1408. 1. Enforceable contract cannot be assailed by the third person. 2. Strangers cannot assail enforceable contracts. Number 1. The loss of the effect of the contract cannot be criticized by the another person who is not included in the contract. Number 2. Just a stranger cannot attack the validity of voidable contract. So, also, they cannot attack the contract because of its enforceability. Indeed, the statute of frauds cannot be set up as a defense by the strangers of the transactions.
For example, agrees to sell 100 kilograms of rice for 10,000 pesos, but there was a huge flood in the States and all the rice crops were destroyed. Now, this contract is enforceable and cannot be enforced against either party.
I am Life Justin Eusebio, your reporter, TVC News.